Hi, my name is Marco Schifferl and I'm a partner at zeiler.partners here in Vienna. In my short clip I am going to speak about the challenge of arbitrators. The decision whether to challenge an arbitrator or not is never an easy one. The hurdle for success is very high. Pursuant to the ICC, the world's most renowned arbitral institution, only 10 to 15% of all challenges succeed. On the downside, in case of an unsuccessful challenge, the challenging party may end up with a disgruntled arbitrator over the further course of the arbitration proceedings. Not a very nice situation to be in. So as a first step, it is extremely important for the party considering a challenge to carefully evaluate the success chances beforehand. Under most arbitration rules and arbitration laws, a challenge can only be based on an arbitrator's lack of independence and impartiality. Laziness, sloppiness, incompetence of an arbitrator is usually not enough. The standard of independence and impartiality is an objective one. This means that it is not relevant whether the challenged arbitrator considers herself to be independent and impartial. Rather, it is decisive whether in the eyes of a reasonable party there are facts and circumstances that give rise, again, to reasonable doubts as to the arbitrator's independence and impartiality. While this has to be decided on a case-to-case basis, luckily there are rules and guidelines categorizing certain recurring situations as meriting a challenge or not. By far the most important ones are the IBA guidelines on the conflicts of interest in international arbitration that can be downloaded for free from the IBA webpage. Due to their great success and acceptance, the IBA guidelines have become something like an industry standard. They are often taken into consideration by the entities deciding on the challenge, be it arbitral institutions or even national courts like the Austrian Supreme Court. To provide some examples, if an arbitrator's law firm, even without the involvement of the arbitrator and in a completely unrelated matter, is advising one of the parties, a challenge will likely be justified. However, generally is not sufficient if the arbitrator and one of the parties' counsel have sat together on a different arbitral tribunal in a different matter. This is even the case when they currently sit together on such arbitral tribunal. Certainly not sufficient is the fact that the arbitrator and one of the parties' counsel have held a presentation together at a conference or have published an article together many years in the past. Once a party has decided to go forward with the challenge, the question is whether, where to file it and within what time frame. This depends on the rules and underlying law applicable to the arbitration. In institutional arbitration, a challenge is usually brought before the arbitral institution. Hence, for example, under the ICC rules, the ICC court will decide on the challenge. If this ICC arbitration took place in Austria, in case of a successful challenge, there is no further recourse. However, in case the challenge was rejected by the ICC court, the challenging party has a second chance before the Austrian Supreme Court, who then renders a final decision. Having once decided to challenge, the challenging party has to act rather fast. After becoming aware of the circumstances for a challenge, the challenge must be filed within a certain deadline. This is 30 days under the ICC rules, but a mere 15 days under the Vienna rules or the Swiss rules. I hope my presentation was helpful, and while it may have looked like that I'm sitting before the camera in the middle of the night all alone, in fact, one of our two cats has kept me company. Good night and good luck.